FFM Academy, Episode 1, The Lawyer.
All right, I'm Dan from Feature FM. I am joined here today by Ryan Schmidt, artist turned music and entertainment lawyer. Ryan has the real hands-on experience, knows what artists go through, and also shares amazing knowledge on all of his socials. So, hi, Ryan.
Hey, thank you so much for having me. I'm excited to be here.
So, Ryan, we met in the very early days of Feature FM. We do have a history that goes back, and it kind of came full circle recently when we reconnected. You were one of the first artists that we ever did an artist spotlight on. This was back when we were in the early days of launching as a company, and you were coming out with the song Killer Bee, which is still an awesome record.
Thanks so much. Yeah, Feature FM, even back in those days, was such an important part of my singer-songwriter journey. And Killer Bee is actually going to be back up online. I took it down when I went to law school. It's actually going to be back up online next month.
That's awesome. We can't wait. Definitely make sure to check it out when it's re-released.
I appreciate that.
Um, so now you're a lawyer. Now you are on the other side of the fence helping artists through navigating all of the legal and business challenges that might be happening in the industry. So my first question is for artists who are serious and want to do this professionally, that really want to have a career in music, what are some of the steps they should take to properly set themselves up as a business and ensure that they really have all of the right protections in place?
It's a great question. I think that one, it's artists enter this new mindset where they're like, I'm going to do this professionally. I'm moving on from just a hobby. There's really important steps they need to take to protect themselves legally. I generally recommend getting an LLC for your business. It is going to limit your personal liability and protect your personal assets. And it's also going to have some important tax benefits. So getting an LLC, usually with your home state, pretty affordable, pretty cheap, but it can give you some really great protections to keep your personal money and your business money separate if anything were to ever happen. Another thing that's, I think, even more important and more of the day to day legal is making sure that you have agreements with everybody that you interact with in your music business, especially with collaborators. Can't tell you how many times somebody's written a great song. They don't have any type of agreement with their co-writers, their producer, anybody else that played on that record. And now there's a dispute over who owns the copyrights, what percentage of royalties are they entitled to, and it can become a huge mess. So getting those types of contracts, including a split sheet and a work for hire if you don't want somebody to have ownership, an artist producer agreement, these are all really important, really necessary contracts that need to be done on a song by song basis. It's really not an option to not do it. It's something that's easy and needs to be part of your toolkit.
Yeah, so it sounds like one of the most important things artists can do is really account for the splits and who owns the intellectual property. And on that note, what are some of the other basics that artists should keep in mind when it comes to protecting their intellectual property?
Definitely consider, if you're based in the United States, definitely consider federally registering that copyright with the US Copyright Office in both the composition, the publishing, and the sound recording, the master. Those are two different copyrights that are generated from your song, and each are eligible for their own copyright registration and protection. The Copyright Act is confusing, and artists are forgiven in thinking, I don't actually need to go register this because the Copyright Act says that I automatically get copyright protection the second I put my work in any tangible form. That is true, but that doesn't give you all of the extra protections that you generally think about with copyright. When you federally register it with the US Copyright Office, now you have the right to sue for copyright infringement. You can't even get into court until you have it federally registered, so you might as well do that on the front end. You also have the right to collect statutory damages and attorney's fees, and you have a federal public record of the fact that you own this work and when you released and published it. All can be very, very good evidence that you own this work.
So if you don't register your copyrights federally and then somebody actually infringes on your IP, you can't even take them to court until you then go and register it.
Yeah, exactly. You would have to go and register anyway. But then at that point, because the infringement happened before your registration, you would lose out on the right to collect statutory damages and attorney's fees. There are some, I would say, penalties for not doing it in the proper order.
Oh, that makes sense. And then when it comes to just thinking about your music being registered in all the right places, so there's the intellectual property registration. What about actually making sure you're paid everything that you're owed? What should artists do to ensure that they're getting paid everything that's owed to them when they are releasing or writing music?
Super important. If you are just collecting what your distributor is making, you are only getting about 65 to 70% of the money that comes in for your recording. And you're leaving a lot of money on the table, especially on the publishing side. So traditionally, a distributor only collects the master royalties. That is sales and streams of your sound recording. And there are exceptions to that if they have also agreed to take on and collect your publishing. And that's a whole nother ball of wax, whether or not you should allow a DIY distributor to take that additional step because you're giving up some important legal rights. What you do want to make sure is that you or somebody working on your behalf is collecting your publishing. And at minimum, that's going to be registering with your performance rights organization. In America, that could be ASCAP or BMI. Registering with a mechanical rights organization. In the US, that's the MLC. And also registering with a neighboring rights or master performance organization. In America, that's Sound Exchange. So having those three would put you in a really good position. If that all sounds too daunting, I like to make music. I don't want to worry about registering all my music, making sure that it's collected everywhere internationally. Then you might want to consider teaming up with a pub admin. This is a company like Songtrust, Centric, Cosign. And these companies will register and collect all your royalties in exchange for a fee. It's usually 15 to 20% of what is collected.
No, that makes sense. So you can go and register separately everywhere, or you can work with a pub admin and pay them a small fee, but be able to spend more time on actually creating the music.
Absolutely.
What are some of the biggest legal mistakes that you run into? Is there a common theme or trend that you tend to see a lot of when it comes to artists in navigating the legal landscape?
Well, the first one, the most common one I see is just lack of any type of paperwork between collaborators. That one is easy enough to fix on the front end, but can be very difficult to fix on the back end. People are generally very happy and excited about working together and talking about whatever their agreement is before something has become very, very successful. On the back end, people may change their tune, they may forget. So that's definitely the most common. But other things that I see is waiting for whatever reason, waiting a long period of time. Time is not your friend when you are trying to assert your legal rights or collect your royalties. Things go away. On the legal side, there's known as statute of limitations. Basically, there is a law that says for this type of claim, whether it's copyright infringement, breach of contract, or something else, you only have a certain amount of time that you can bring that claim. Otherwise, you lose it. And that can be very unforgiving. And for copyright infringement, that's 3 years. And I know that there's a lot of artists that they find out about something, they say, that doesn't seem right. I'm kind of busy right now. It sounds like a pain in the butt. I'll get back to it at a later time and I'll deal with it. And usually I hear from producers and artists who might have had a song in the late 90s, early 2000s. And they're like, I knew that I was supposed to get royalties on this. I was supposed to get paid as a producer and I never got that. They breached the contract. I want to go after them now. And I have to give them the bad news that you just waited too long. And so time is not your friend with any of these things. Remember what your obligations are and what people's commitments are to you, and don't sit on it forever. Same thing with royalties. If you don't register and collect your royalties within a certain amount of time, those are also going to go away because BMI or ASCAP might have collected that money, but they don't know where to send it to. So they're not going to hold on to it forever because you're not telling them, hey, that's my money, send it to me. So that's also a very, very common legal pitfall for artists and musicians.
Now, my next question might be part of the same theme around making sure that you have everything in place with collaborators, but what are the most important and standard contracts or agreements that artists should always make sure that they have in place or that they're prepared to have with people on their team as well as collaborators?
Absolutely, yeah. So on the publishing side, the composition copyright, you got to have a split sheet. That is going to confirm at minimum the ownership and percentages of that composition. We wrote this song on this date. It's owned 50-50 between Ryan and Dan. Here's our ASCAP BMI info. That is signed, dated. You keep it and put it on the cloud. You put it in your documents. You make sure that you hold on to it. Now you have a record of what the ownership of the composition is. On the master side and on the publishing side too, it's really important to use work for hire agreements. Anytime you want to pay somebody, but you don't want them to be a co-owner of the copyright. And this can be you hire somebody to play a guitar solo on your recording, or it could even be you hire a graphic designer or a director to shoot your music video, because the Copyright Act says the creator of the work is actually the owner, unless there's an agreement that says otherwise. So if I pay somebody to do the artwork for my album, just because I paid them doesn't mean that they're not the creator and author of that copyright. So we need an agreement, which is a work for hire, that says in exchange for me paying you this money, you agree that I own and retain all the copyrights. Very, very important. Otherwise, it's whoever created that work. An artist-producer agreement, another thing that is really important, and that will cover both. That'll generally replace the split sheet as it relates to the artist and the producer. And for whatever songs that you're working on together in that project, it could be a song by song basis, an album by album basis, but it's going to cover things like the producer fee, what the producer has to deliver, what the producer's royalty rate on the master is going to be, what the producer's split on the publishing, if any, is going to be. And that's also incredibly important. Outside of that, really anybody that you are engaging with and you are paying money to, or there's some exchange of value, some exchange of copyrights, always have a contract in place. In the management side of things, it's very, very common for artists and managers to have handshake deals. And I don't knock that practice because there's been plenty of really successful long-term artist management relationships that have worked that way. But when it goes bad, it goes really bad. And at minimum, I think you want to have at least some understanding in some form of writing. It could just be, hey, I had a great meeting with you today. I want you to be my manager. Here is an email confirming the basic terms of that. And the other side says, yes, I agree. Now we have some written agreement, but it'd be better to have a long form artist manager agreement, especially because what happens is an artist and manager have been working for a really long time. The artist gets to a certain point. Usually some other manager comes in and says, hey, I think I could be doing a better job than your current manager, and promises them all this stuff, whether or not they can actually deliver on that. They fire the first manager, but the first manager and the artist had some agreement that even after the manager was fired, that they would get some diminishing commissions over time, also known as a sunset. And we're currently seeing a litigation that's been going on for years and years with Chance the Rapper and his former manager about this. And it was all a handshake verbal deal. And we're talking about millions of dollars in unpaid commissions. You don't want to leave it up to that, because the amount of money they're spending on that could have been avoided had they just had an agreement that said, this is what we're going to do. I mean, it's clear why you want that.
I think in the music industry, in our industry, we see a lot of people that just want to move fast and break things. And that's okay. And a lot of times that does work out. But the purpose of having these contracts in place, it's an insurance policy, essentially saying, what if something happens that we disagree on? And having that kind of pre-agreed upon makes it much easier down the line when there might be a dispute or a disagreement. And you want to go back and say, well, what did the contract say? For our business as well, sometimes you're negotiating terms in the contract, you're negotiating like worst case scenarios. And these are things that you don't expect to ever happen, that shouldn't ever happen. But in case they do, at least you have thought about it ahead of time.
Absolutely. Yeah. It's one of those things that I think some people think that contracts can signal to the other side, I don't trust you. And I think that it might be disrespectful. I think the opposite. I think it's very respectful to say, I care about this relationship so much that I don't want to end up in a dispute over things that we clearly don't have any disagreement over. Let's just write this down and agree
Yep.
to what we agree to, because I don't want us to end up in some messy dispute in the future.
So I want to bring up a topic that is very popular now, and it's the topic of AI. We see AI technology is moving extremely fast. We see companies popping up every day, whether they're generative or whether they're more assistant based. As far as AI goes, what are some of the top of mind legal discussions that are happening around AI in the music space, and anything that you see that artists should be making sure that they're thinking about?
For AI, there's two main laws where we're seeing the main battlegrounds taking place. There is copyright, and then there's also the right of publicity. On the copyright side, we've been seeing a whole bunch of lawsuits, both from whether or not the AI company unfairly trained their models, if they violated somebody else's copyright on the input side. And then we're also seeing copyright lawsuits on the output side. The output that AI is creating is too similar to my protected work. We're seeing with the big three and the RIAA have sued Suno and Udio for that very reason. And there have been some federal court decisions with other similar AI companies that have held that training is not fair use, and therefore it can be grounds for copyright infringement. Whether or not these judges in these cases will rule that way remains to be seen. But that's the main copyright issue right now, is whether or not AI companies have the right to take copyrighted materials, train their models, and then use that to create new works. It's rapidly developing. There's a big debate over which side you should be on. On the one hand, it is helping innovation, and you need a large data set. And the people that are on the AI side say it's very similar to how humans learn. They're just learning a ton of information instead of just one song at a time, or however humans would generally learn. On the rights holder side, they're saying, yes, but this is my work that you are incorporating into your software, and that's an unauthorized recreation of my work, and therefore copyright infringement. I think, pessimistically, I think that the creatives are going to lose that argument ultimately. I think judges may say that it's infringement, because some judges have already said that. But practically, many countries that are creating AI are operating outside of that. That isn't even a limitation. And so the CEO of OpenAI has said that we're essentially in an AI arms race with different countries, including China. And they're not playing by any rules of copyright. And if we want to be the global superpower of AI, then we can't be limited in this way as well. I think that that's going to have a lot of weight, both with our current administration and with legislatures, that, this is something that they want to win the AI arms race. And I think that that will impact and influence copyright law, for better or for worse. So that's the copyright side of thing. On the other side, there's the right of publicity, and that is your personal right to your name, image, and likeness. It's essentially a privacy right. And currently, it's a state law right that varies from state to state. There's only about 25 states that have any type of protection for this, and it varies drastically. So if somebody stole my likeness, depending on where I lived and where they lived, it may be legal, it may be completely illegal. It could be that I would have to be a celebrity or known public figure for that to apply, or I could only do it if I was a service member or a politician or something like that. There's currently a bill with the US Congress called the No Fakes Act, which would do away with all that, would do away with different rules in every single state, and would create a uniform federal likeness right that kind of mimics copyright. You'd have this right your entire life plus 70 years after you die, which is the same length of copyright under the US Copyright Act. And any type of unauthorized use of your likeness would be something that you could protect and you could go after. And there's a few limitations for like First Amendment, kind of fair use, parody. But generally, it's something that is going to give just normal, everyday people rights to be compensated if some deep fake does harm to their reputation. And in the music community, I think it's very, very important because we've already seen a few AI deepfakes come out. And you can imagine the harm that that could cause, not just that somebody is monetizing off of a well-known singer's voice and that the singer should cash in on that, but also what could happen if somebody took Taylor Swift's voice and then made a super racist song or something like that, put words in your mouth that caused you reputational harm and damage. That is the No Fakes Act, and I do imagine that that will be passed. I do think that there's really good bipartisan support on both sides for that.
So we'll need to keep following what happens with legislature, what the judges say. It's such a new technology and impact that AI is having that we'll need to keep following how the rules actually shape how it ends up being used. I think we see definitely a lot of AI anxiety out there of people trying to feel like they're not being left behind, but also not fully understanding exactly how they could be or should be using AI technology to grow and to navigate the landscape of their careers.
Well said.
So your advice has been amazing. I think artists can absolutely learn a lot from you and from what they need to do in the legal space. But this all seems extremely daunting, right? I think when artists, especially artists that are DIY and kind of putting their own teams around them and building their own careers, they have companies like Feature FM telling them they have to be digital marketers and here's everything you need to do around digital marketing. And now they hear on the legal side, there's all these tasks and all of these protections that you need to make sure you have in place. They also need to create the music and release the music. And it seems like there are not enough hours in the day for artists to make sure that they're doing everything they need to. Do you have any advice of what artists can do to make sure they're able to actually prioritize everything they need to when it comes to this like daunting list of tasks that it feels like they have to accomplish?
Well, one, I would say, and this is advice that I'd give to myself 10 years ago as a solo singer songwriter, is just because you're independent doesn't mean that you have to do every last thing yourself. There is only so many hours in the day, and there is a lot of work that needs to be done. But that doesn't mean that you have to go it by yourself, whether that's hiring a lawyer or finding a manager, maybe even just finding a college roommate, a best friend, a parent, somebody that can help with some of this admin work that allows you to focus on some of the more creative endeavors. What's your marketing and rollout strategy? What's your studio session going to be? This, that, the other thing. I think that there's too many independent artists that feel like being indie means I must do it all myself, and that's just not true. For the legal side, there are lawyers like myself that do offer consultation services where we'll talk to you for an hour and we'll go over everything you got going on, and I'll give you all the contract templates that you need to incorporate into your future songs for you to feel confident that you're doing things the right way. But I do think that It's pretty good for a musician to have somebody take a look at what their processes and infrastructure, especially around the business and the legal side of things, are on the early end. Once you decide that this is what you want to do, because you don't want to wait. Time is not your friend. You know, that lawsuit went away, those royalties are gone. You want to have everything kind of buttoned up as soon as possible.
So, do artists need to have a lawyer on the team early on? And what would you say to artists that say, hey, let me go ask my lawyer, and then they go ask ChatGPT real quick to help write them contracts or make sure they're doing things legally?
So I think that there's two important times for an artist to get a lawyer. One is just the subjective place where you decide, I want to take this seriously and I want to be a professional musician. When you hit that level in your mind, that's a great time to reach out to a lawyer, make sure that you are set up for success, that you're doing the right things and you've got a plan in place. The other one, of course, is anytime you're presented with a contract that has long-term consequences. This is going to be a record deal. They're going to own your copyrights. This is going to last for a number of years. A management deal, publishing deal, anything like that that's going to last a long period of time. You really want to make sure that you understand what you're getting into. As far as ChatGPT, it's one of those things that it's a fantastic tool. And what I worry about with artists relying on it is they don't necessarily have the context to know whether or not the advice they're getting is good. If I put something in ChatGPT, I, as a lawyer who's legally trained, can say that advice was terrible. Like I would never do that. Would never advise somebody to do that. But I think there's too much blind trust in, well, ChatGPT recommended it, so let's go ahead and do it. The other issue I see is that chat responds based on what your prompt was. It does exactly what you ask it to do, for better or for worse. And sometimes what you're asking it to do can actually be illegal, or it can be something that's going to have real consequences. I saw something the other day where they're based in California, but they have their business set up in Delaware. And so in this contract that they had ChatGPT draft, it said that jurisdiction was proper and that the governing law of the contract was both California law and Delaware law. That sounds like pretty harmless, but now if there's ever a dispute, we are now fighting over which law applies. We're not even getting into what happened because we need to know which law. We can't just blend two different laws together. They're completely separate. So now we have to decide which law did the parties intend and this, that, the other thing. And now that's its own issue. The other thing is formatting is generally garbage. It's only as good as the data set that it knows. So if it has seen a really good management agreement and you say, give me a management agreement, then it might do a pretty decent job. But if you just give a simple prompt, like give me an artist management agreement, it's going to give you like bullet points. It's probably not going to number anything. It's going to be really bad. I say to artists, if you ask me to polish up a ChatGPT contract, that's going to be about 3 times as much work and 3 times as much money than if you just let me draft one from scratch, from a template that I work off of, that I know of, because this is a mess. And it used to be like artists would go online, they get a template on Google. And those are 10, 100 times better than ChatGPT, because at least that was maybe drafted at some point by a lawyer and it follows some type of logical contract form. Yeah, so that's what my thoughts there. I think it's great to summarize agreements. Maybe you ask it to give you the high level points in plain English, not in legalese. But I think as far as reviewing it and coming up with red lines and stuff like that, that's really not great. And also the last thing I'll say on that is that it's trained on publicly available information. I think that's the most important thing, is like, I only know what is standard right now with a label deal or a management deal or a publishing deal, because I'm working on those every single day. And I can see the trends and I can see the percentages and they're doing this, and I can actually push back and say, look, nobody's doing this. This is way outside of what is standard. But that secret sauce is something that I've learned because I'm doing this every day. that isn't necessarily built into ChatGPT.
Ryan, thank you so much for all of the amazing knowledge and advice today. Really appreciate you joining.
Oh,
And
my pleasure.
thanks for being here.
Absolutely. Thanks.